Hello dear students, this video is my second video for the subject Business Law. In the previous video, I have given an introduction for this subject Business Law. So, before you proceed to watch this video, I will advise you to watch my previous video so that you can understand the contents of this video better. Let me proceed further now. So today I am going to tell you regarding the Indian Contract Act. As I told in my previous video, the Indian Contract Act 1872 is primarily based on the English Contract Act. So the base for the Indian Contract Act 1872 is the English Contract Act. The law relating to contract is contained in this Indian Contract Act. So the Indian Contract Act 1872 deals with the law relating to contract. Actually, the act deals with the general principles of the law of contract, that is the first category, and it also deals with some special contracts. Okay, so this Indian Contract Act deals with the general principles of the law of contract, and this is given in sections 1 to section 75. Okay, to be even more clear, the first 6 chapters deal with the different stages in the formation of the contract, its essential elements, its performance, breach, and remedies for breach. Okay, so all this will be dealing as separate chapters later. So I will be giving you clear explanation for all this. For the time being, try to understand that the first 6 chapter deals with the different stages in the formation of the contract, its essential elements, the performance of the contract, breach of contract. Breach of contract means failure to perform the contract, and what are the remedies available when there is a breach of the contract. And then as a second part, we have some special contracts, and this is dealt in sections 124 to section 238. So the remaining chapters of the Act deal with the special contracts. And what are special contracts we have here? We have special contracts like indemnity and guarantee, bailment and pledge, and then contract relating to agency. Okay, so this is what is about the Indian Contract Act 1872. Now, let us proceed with the definition of contract. Define a contract is a very important question in this subject, business law. So when you are asked to give the definition, you have to give the definition as per the Indian Contract Act 1872. So remember, it is section 2 subsection H of the Indian Contract Act 1872 which defines the term contract. So I have given you the definition here. Definition we have to write only as it is. So you have to by heart the definition. So what is the definition we are having for this term contract? Section 2 subsection H of the Indian Contract Act defines a contract, and according to the section 2 subsection H, contract is an agreement. Contract is an agreement enforceable by law. So what is the definition for contract? It's a very simple definition. Contract is an agreement enforceable by law. So if you analyze this definition, contract is an agreement enforceable by law, you can very clearly know that contract consists of 2 essential elements. So what are the 2 essential elements? The first essential element is agreement. So there should be an agreement basically, and the second one is its enforceability by law. Okay, so there should be an agreement, then such an agreement should be legally enforceable. Only then it will result in a contract. Now, when you say agreement, what is an agreement? You have to understand. So in order to form an agreement, first of all, there must be an offer or proposal by one party and its acceptance by the other one. The one who proposes is called as the offerer, and the one to whom the proposal is made is called as the offeree. So there should be an offerer and offeree, and only then the agreement will come into existence. Okay. So to be very very clear, when you say agreement is equal to offer plus acceptance. So what is actually an agreement? An agreement is equal to offer plus acceptance. So what does it mean? To form an agreement, first of all, there should be an offer or proposal by one party and its acceptance by the other party. Only then an agreement will come into existence. So whenever we talk about an agreement, you should be familiar with a Latin phrase that is consensus ad idem. Let me write it here. Consensus ad idem. So you have to know the meaning for this. Consensus ad idem. So let me tell you what is the meaning of this consensus ad idem. So let me tell you what is this consensus ad idem. This means that is consensus ad idem means that the parties to the agreement must have agreed about the subject matter of the agreement in the same sense and at the same time. So what is consensus ad idem? It means that the parties to the agreement must have agreed about the subject matter of the agreement in the same sense and at the same time. Let me make it very very clear to you. I already told you that two parties will be there in an agreement, isn't it? One person making the offer called as the offerer and the other party giving the acceptance called as the offeree. The offeree should understand the subject matter of the agreement in the same way as it was communicated by the offerer. Then only you say that there is consensus ad idem. So let me make it even more clear with a very simple example. Let us assume that a person by name Ram owns two cars, one red car and another blue car. Okay. Ram offers to sell his red car to Shyam for 5 lakh rupees. Okay. Ram offers to sell his red car to Shyam for 5 lakh rupees, and Shyam is giving his willingness and acceptance to buy the red car. Here there is consensus ad idem because the offeree has understood the subject matter conveyed by the offerer in the same sense. If Ram simply says that I will sell my car to if Ram simply says that I'll sell my car to Shyam simply without specifically mentioning which car, there is no consensus ad idem because the other person, namely Shyam, is not clear regarding which car Ram wants to sell. So there is no consensus ad idem and this cannot result in a proper acceptance. Okay. So what is very very essential is the presence of consensus ad idem is essential. That is why it is said that if there is no consensus ad idem, there is no contract. Okay. So only if there is consensus ad idem there can be a valid contract. Now an agreement becomes a contract only when it results in legal obligation. What is a contract? What is the definition as given by section 2 subsection H of the Indian Contract Act? A contract is an agreement enforceable by law, isn't it? So there should be an agreement and at the same time it should be legally enforceable. To be very very clear, a contract is equal to an agreement plus enforceability. At law. So it should be legally enforceable. So all agreements will not result in contracts. Only if the agreement is legally enforceable, it will lead to a contract. So what do you mean by this? Sometimes there will be social agreements, isn't it? Some social agreements will be there between friends, between family members and all that. In all such cases, the agreement will not lead to a contract. Okay? See, for example, when a person by name A tells B that he will come to B's birthday party. So this is only a social agreement which is not legally enforceable. It will not lead to a contract as such. So what is very essential to result in a contract is that the agreement should be something which is legally enforceable. Okay? If there is no legal enforceability, it will not result in a contract. That is why there is a very important saying, all contracts are agreements, but all agreements are not necessarily contracts. So what do you mean by this? Why do you say that all contracts are agreements? All contracts are agreements because definitely only if there is an agreement there will be a contract. But all agreements are not necessarily contracts. Why? Sometimes you may even have social agreements. Social agreements will never lead to contract, and in case if there is any breach of social agreement, that is failure to perform social obligation or social agreement. When I gave you the example, I told you, if the person is not attending the birthday party, no legal action can be taken against him because it's only a social obligation, it's only a social agreement. Okay, when there is a social agreement, it will not lead to a contract. So what is very, very essential to result in a contract? Basically, there should be an agreement between two parties. Okay, and such an agreement should be legally enforceable. So contract is equal to agreement plus enforceability at law. This is what is given by the definition. As I told you earlier, section 2H of the Indian Contract Act 1872 tells you that contract is an agreement enforceable at law. And this is what is the meaning for the definition given by section 2 subsection H. So in this video, I have given you some basic information about the Indian Contract Act 1872. I have given clear explanation for the term contract as defined by section 2 subsection H of the Indian Contract Act 1872. I hope you are clear with the explanation. In my next video, I will be explaining the essential elements of a valid contract. So if you like this video, subscribe to my channel and forward it to your friends also. Please don't forget to give your comments so that I can post videos according to your requirements and expectations. Thank you very much for watching this video.